Hello everybody, I am Taniya Pandey and I welcome you to Courts This Week on LiveLaw. Every week we bring you details of the most recent judgments in a nutshell so you don't miss anything important. So definitely subscribe to LiveLaw to continue to be with us. As usual, let's begin the episode with judgments from the Supreme Court. The Supreme Court on 18th August passed an interim order to allow women to take the admission exam to National Defence Academy scheduled for 14th November. The result would be subject to final adjudication of the petitions. The bench of Justices Sanjay Kishan Kaul and Rishikesh Roy also directed the UPSC to take out a suitable corrigendum notification in view of the order and give due publicity so that the intent of the order is translated into effect. This public interest litigation raises the issue of violation of Articles 14, 15, 16 and 19 of the Constitution of India by denying the opportunity to eligible and willing female candidates to join the NDA and afford them a chance to enroll, train and develop themselves in the NDA into future leaders of the Indian Armed Forces. The Supreme Court on 17th August issued notice before admission to the central government in a batch of petitions seeking probe into the Pegasus snooping controversy. The bench of Chief Justice of India N.V. Ramana, Justice Suryakant and Justice Anirudh Bose will hear the matter further after 10 days, which has sought court-monitored inquiry by a special investigation team or a judicial probe into reports of alleged snooping of activists, politicians, journalists and constitutional bodies using the Pegasus spyware. The court said that they will discuss what needs to be done if a committee of experts or some other committee needs to be made. While hearing a batch of pleas where an interim order staying arrest was granted in Prevention of Money Laundering Act cases, the Supreme Court on 17th August observed that there would be no stay in trial or investigation in cases where order of no coercive simpliciter has been passed. The full bench of Justices A.M. Khanvilkar, Krishna Murari and V. Ramasubramanian said that the order did not result in staying the trial or investigation and that the petitioners in the concerned cases could take remedies in accordance with law. The top court also permitted the investigating agency to insist for depositing the passport or complying with any other condition imposed by the agency, irrespective of the order for no coercive simpliciter. The Supreme Court has issued notice in a plea filed by a widow seeking cancellation of the bail granted to her mother in a case of honor killing of her husband. The bench of CJI N.V. Ramana, Justice Suryakant and Justice Anirudh Bose issued notice after hearing submissions made by Senior Advocate Indira Jaisingh appearing for the petitioner widow. The petitioner averred that the only grounds considered by the High Court in granting bail are that the completion of trial was taking time and that the bail application of the co-accused Mukesh Chaudhary, who is the petitioner's brother, was granted bail on 1st December 2020 by the High Court, but even his bail has now been cancelled by the top court on 12th July 2021. The Supreme Court has observed that a tenant in sufferance is not entitled to any protection of the Rent Act against Sarfazi proceedings due to the operation of Section 13(2) read with Section 13(13) of the Sarfazi Act. A tenant in sufferance is a tenant whose term has expired but who has not vacated yet. The bench of Justices S. Abdul Nazir and Krishna Murari observed that in the absence of a registered instrument, if the tenant only relies upon an unregistered instrument or an oral agreement accompanied by delivery of possession, the tenant is not entitled to possession of the secured asset for more than the period prescribed under the provisions of the Transfer of Property Act. The Supreme Court has observed that a motor accident claim petition does not abate even after death of the injured claimant. The right to sue survives his legal representatives insofar as loss to the estate is concerned, the bench of Justices Naveen Sinha and R. Subhash Reddy observed. The court noted that in the Madhuben Maheshbhai Patel judgment, the Gujarat High Court held that even after the death of the injured claimant, claim petition does not abate and right to sue survives to his heirs and legal representatives insofar as loss to the estate is concerned, which would include personal expenses incurred on the treatment and other claim related to loss of estate. The Supreme Court has observed that while determining compensation under the Motor Vehicles Act, a court cannot direct the continued maintenance by insurance company of a prosthetic limb for the injured claimant. The process of determination of such compensation cannot be made by a continuing mandamus in a colloquial sense, and the determination must take place in one go the bench of Justices Sanjay Kishan Kaul and Rishikesh Roy observed. In this case, while allowing an appeal filed by a claimant, the High Court directed that he shall be supplied a prosthetic limb of good quality and with a lifetime warranty. It was further directed that if any repair or replacement has to be done, the same should be done by the insurance company and that it should inquire from the victim at least twice a year as to the working condition of the prosthetic limb with an email address and telephone number specified. The top court set aside these directions and observed that the same shall be substituted by the determination for amount required for maintenance or replacement of the prosthetic limb, while a quantification of the amount for compensation is being made. Merely because an arrest can be made because it is lawful does not mandate that arrest must be made, the Supreme Court recently observed. The bench of Justices Sanjay Kishan Kaul and Rishikesh Roy observed that personal liberty is an important aspect of our constitutional mandate. In this case, the appellant, along with 83 other private persons, was sought to be roped in an FIR which was registered 7 years ago. Before the court, he submitted that he had already joined the investigation and the charge sheet was stated to be ready to be filed. As the arrest memo was issued, he filed an anticipatory bail application before the High Court, which was dismissed, and he then approached the Apex Court in appeal. The court observed that the trial court, in this case, has taken a view that unless the person is taken into custody, the charge sheet will not be taken on record in view of Section 170 of the Code of Criminal Procedure. On this aspect, it held that Section 170 of the CRPC does not impose an obligation on the officer in charge to arrest each and every accused at the time of filing of the charge sheet. Now it's time for judgments from the High Courts and other courts. While protecting interfaith marriages by consenting adults from the rigors of the Gujarat Freedom of Religion Amendment Act 2021, the Gujarat High Court prima facie observed that the law interferes with the intricacies of marriage, including the right of the choice of an individual, thereby infringing Article 21 of the Constitution of India. A division bench of Chief Justice Vikram Nath and Justice Biren Vaishnav observed that the provisions of the law, commonly known as the Love Jihad law, put parties who had validly entered into interfaith marriages in great jeopardy. The court noted that the Gujarat Freedom of Religion Act 2003 was brought to ban conversion by force or allurement or fraudulent means. The 2021 amendment brings conversions due to marriage through force or allurement or fraudulent means under the purview of the Act. The court has held that these provisions will not apply to interfaith marriages based on free consent by adults. During the hearing, the bench had orally observed that religion and marriage were matters of personal choices. As per the stringent provisions of the Act, the moment a person makes an FIR against an interfaith marriage, the persons can be sent to jail. Also, the burden of proof is on the accused. The Lucknow bench of the Allahabad High Court has held that for issuing of proceedings under Section 82 of the Code of Criminal Procedure, the investigating officer has to seek the help of the court, and only under the orders of the court can proclamation under Section 482 CRPC be issued. Justice Saroj Yadav observed that it is settled that if the accused evades arrest during the investigating officer has power to arrest the accused without a warrant if the offence is a cognizable one. The court noted that the investigation is ongoing in the present matter, which relates to the death of a person by consumption of toxic liquor. However, it also noted that the magistrate should not routinely pass such order on the simple application of the investigating officer. Instead, the application should be supported by an affidavit of the investigating officer stating why an NBW and proclamation under Section 82 CRPC is required, as the issue relates to the personal liberty of a person guaranteed under Article 21 of the Constitution of India. The Delhi High Court has granted ex parte ad interim injunction to Gujarat Cooperative Milk Marketing Federation Limited, popularly known as Amul, in a trademark infringement suit which alleged that a company was using a misleading mark, that is Amul cookware, for selling kitchenware and utensils. Observing that a prima facie case is made out in favor of Amul, Justice C. Hari Shankar observed that the word Amul is distinctive and has no etymological meaning. It is indelibly associated in the minds of the consuming public with the products of the plaintiff. Prima facie, any use of the word Amul as a trademark by any other entity may tantamount to infringement. The Allahabad High Court has recently observed that for the purpose of the exercise of power under Section 319 of the CRPC, The evidence recorded by the court during the trial is to be given primacy over the material collected during investigation. The court noted that the word evidence used under Section 319(1) of the Code has been held to be understood to refer to the evidence recorded during the trial and also any material that has been received by the court after cognizance is taken and before the trial commences to be utilized for corroboration and to support the evidence recorded by the court. The Allahabad High Court came down heavily on the police department for dealing with the molestation case of a 15-year-old girl in a very casual and insensitive manner. The bench of Justice Rajbir Singh directed the Superintendent of Police District Chitrakoot to take strict action against the erring police officials and to file an action taken report before the Registrar General, Allahabad High Court, within a period of 1 month. The court was hearing a bail application filed by the applicant in a criminal case registered under Sections 305, 341 and 376D IPC, Section 4 of the POCSO Act and Section 325 of the SC/ST Act. A 3-member commission approved by the Supreme Court to probe into the encounter of gangster Vikas Dubey has given a clean chit to Uttar Pradesh Police, stating that no suspicion or doubt arises about the police version of the encounter. It was on July 22, 2020 that the Supreme Court had constituted the committee to be led by its chairman, Justice B.S. Chauhan, and members, which includes retired Allahabad High Court Judge, Justice Shashikant Agarwal, and former UP Director General of Police, K.L. Gupta. These were the top stories of last week. To continue staying updated with the latest judgments, do subscribe to LiveLaw and click the bell icon. I am Taniya Pandey for LiveLaw. Have a lovely day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.